the matter of the Manchester Ship Canal Company Limited against United Utilities Water Limited, number 2.
United Utilities is responsible for sewerage in the northwest of England. Its sewerage network includes around 100 outfalls from which material from sewers, sewage treatment works and pumping stations is discharged into the Manchester Ship Canal. When the volume of material being handled by the network is within its capacity, the discharges into the canal are of surface water or treated effluent. But when the network's capacity is exceeded, at least some of the outfalls discharge foul water into the canal, in other words, material contaminated with untreated sewage. The company which owns the canal threatened to bring a claim against United Utilities for trespass and nuisance. In response, United Utilities asked the court to make a declaration that the canal company had no right of action, on the basis that in the absence of negligence or deliberate wrongdoing, any claim was barred by the statutory scheme for regulating sewerage established by the Water Industry Act of 1991. United Utilities argued that only the Secretary of State or the regulator, Ofwat, could take action against them, whereas individuals or organisations with legal rights in watercourses could not. The High Court judge agreed to make the declaration requested by United Utilities. His decision was upheld by the Court of Appeal. The implication of those judgments is that no owner of a canal or other watercourse or body of water can bring a claim based on nuisance or trespass against a sewerage undertaker in respect of polluting discharges into the water unless the sewerage undertaker is guilty of negligence or deliberate wrongdoing. A claim of this kind would be prevented however frequent the polluting discharges might be and however damaging their effects might be on the owner's interests or their ability to enjoy their property. The Canal Company appeals to the Supreme Court. The Supreme Court unanimously allows the Canal Company's appeal. It holds that the Water Industry Act does not prevent the Canal Company from bringing a claim of nuisance or trespass when the canal is polluted by discharges of foul water from United Utilities outfalls, even if there has been no negligence or deliberate misconduct. The starting point is that the owner of a canal or other watercourse has a property right in the watercourse, including a right to preserve the quality of the water. That right is protected by the common law. The discharge of polluting effluent into a privately owned watercourse is an actionable nuisance at common law if the pollution interferes with the owner's use or enjoyment of its property. The next question is whether the Water Industry Act excludes common law rights of action. That is a question of statutory interpretation. The legislation does not expressly authorise United Utilities to cause a nuisance or to trespass. Furthermore, Parliament cannot be taken to have impliedly authorised polluting discharges, since they are not an inevitable consequence of a sewerage undertaker's performance of its statutory powers and duties. On the contrary, the legislation provides that nothing in the relevant sewerage provisions authorises a sewerage undertaker to use a sewer, drain or outfall to convey foul water into a watercourse. It also requires a sewerage undertaker to carry out its functions under the relevant provisions so as not to create a nuisance. If Parliament has not authorised an interference with private rights, then it would normally follow that the victim of an interference can enforce those rights at common law. However, United Utilities argues that the Canal Company has no cause of action because the only way to avoid the discharges of foul water into the canal would be to construct new sewerage infrastructure. It relies on a previous case involving Thames Water, which it says established that Parliament's intention was that the construction of new sewerage infrastructure should be a matter for Ofwat and not for the courts. The Supreme Court rejects this argument. There are a number of indications that Parliament did not intend the legislation to exclude a claimant's right to enforce its private property rights in a watercourse. First, the legislation provides for arbitration where the quality of the water in a watercourse has been damaged without the consent of persons with rights in the watercourse, at the option of the party complaining. This strongly suggests that the complaining party has an alternative remedy to arbitration open to it, which can only be a common law claim. Secondly, the legislation makes provision for statutory compensation to be paid where damage is caused by the acts of sewerage undertakers which Parliament has authorised and which are therefore lawful. But it makes no provision for statutory compensation for damage caused by acts which Parliament has not authorised and which are unlawful, such as the sewage discharges in the present case. This indicates that the victims of unauthorised damage retain their common law rights of action. Otherwise, Parliament would have left them without any remedy for the damage they have suffered as a result of unlawful behaviour, which would be anomalous. It would also mean that the victims of damage caused by unlawful behaviour were treated less favourably by Parliament than the victims of damage caused by lawful behaviour, which would be perverse. Thirdly, if the legislation deprived the victims of a nuisance or trespass of their common law rights of action, that was a substantial change to the law as it previously stood. It's unlikely that a change of that kind would have been made by the legislation, as it was what is called a consolidation statute, and such statutes are not intended to make substantial changes to the law. Moreover, the legislation is detailed and elaborate. It would be surprising if it had left an important change in the law to be implied rather than stated expressly. In addition, there is a principle of statutory interpretation that fundamental common law rights, such as rights of action to protect private property, are not overridden by legislation in the absence of express language or necessary implication. The Supreme Court's conclusion is consistent with the previous decision concerning Thames Water relied on by United Utilities. That case is not directly applicable in this case because it did not concern the pollution of a watercourse, and so it did not involve many of the provisions which are relevant to this case. In addition, Thames Water had not caused the nuisance with which that case was concerned, unlike United Utilities in the present case. Instead, Thames Water was said to be liable for failing to take reasonable steps to prevent a nuisance by constructing a new public sewer. An essential ingredient of the cause of action brought against Thames Water was, therefore, that it was under a duty to build a new sewer. That is a statutory duty, which under the legislation can only be enforced by the Secretary of State or Ofwat, and not by the courts. In contrast, the legal basis of the Canal Company's proposed claim against United Utilities in the present case is not the breach of any duty enforceable only by the statutory regulators, but the breach of common law duties under the law of trespass and nuisance, which exist independently of the legislation. It's true that the polluting discharges could be avoided if United Utilities invested in improved infrastructure and treatment processes, but the Canal Company's action would be based not on United Utilities' failure to invest, but on their commission of a nuisance or trespass. The Supreme Court accepts that the regulatory scheme established by the legislation might be disrupted if the court were to grant injunctions which would conflict with the arrangements in the legislation for the regulatory approval of capital expenditure. However, that potential incompatibility does not mean that common law rights of action are excluded. The incompatibility may, in some cases, militate against the court, in the exercise of its discretion, granting injunctions which require the upgrading of a sewerage system, but it does not follow from a court's conclusion that it should not grant such an injunction that a remedy in damages is also excluded. On the contrary, the courts may make an award of damages both for past invasions of individuals' rights by sewerage undertakers and for future or repeated invasions of their rights. The court will now adjourn.